All righty, let's get going. So it's 9:01. I want to thank everybody for hopping on this morning for our special presentation today on navigating major tariffs, changes, and what contractors need to know now. We have a big group today, so I would ask that everybody stay muted. At the end, we'll have an opportunity to ask questions, and we'll do it through the raise your hand feature under the React tab. But for now, the presentation is being recorded and will be uploaded to the chapter's website. So if you would need to view this after the presentation, it'll be sent out to all attendees. So I'm pleased to introduce our speaker today. It is Nick Solosky, who's a partner within the construction practice of Fox Rothschild. So we're happy to have Nick on today, and we'll turn it over to Nick. Take it away.
Hey, good morning, everybody. Thanks so much for having me. Like Rob said, I'm Nick Solosky. I'm with Fox. I'm based out of Fox's DC office. The group that I practice with is our federal government contracts and construction practice group. Not sure if anybody on the call has any crossover with state or federal contracting work. That's certainly an area that I'm really familiar with, so I'm going to sprinkle in a little bit of that today. If it's not applicable to anybody, there won't be a ton of content on it, but I couldn't help myself. And certainly if that's something that's really something that you're interested in, I'm happy to answer questions about it or talk after the presentation. Yeah, so I think you all are familiar with Fox. My partner, Andrew McDonald, I know has spoken to you all in the past on labor and employment type issues. So Andrew and I, obviously work in different departments, but same firm. And for those, in case it's relevant to anybody, Fox is a national firm, so we're all over the country. And I think there's something like 30,000 lawyers across 30 offices. So if there's an issue that you all have, and I don't know the answer, I'm sure I can find one of my partners that does. And speaking of which, one of the things I want to be clear about today, covering why we're here. My specialty in this area is going to be on, how the tariffs generally, and certainly the recent tariffs from the administration, either actual or threatened, are going to impact your existing or contemplated contracts. What I'm not going to be in a position to tell you all is how the sausage gets made on these tariffs, how they're enforced at a granular level, when they're imposed and all that kind of stuff. In connection with the slide that you all can see right now, consulted with our international trade folks who have a better sense of exactly how that process takes place. But I don't want to hold myself out as someone who can tell you, hey, for this particular project, how is this tariff going to be imposed? That's not really my area. But certainly I know that the major tariffs that are affecting your industry right now, certainly that first bullet point, the broad-based tariffs on Mexico, Canada, and China, I know are really significant. I know that I think that there's a upcoming April 4th inflection point where those tariffs either will or won't really take hold. There's the separate 25% tariff on steel and aluminum, which I'm sure is already kind of creating some chaos or instability, at least in your markets. And then the third bullet point, this all is within the context of tariffs that already existed prior to the current administration, things that have been in place. And I think it's important for you all to understand that this is not a kind of order of precedence situation. In other words, it's not like, well, which tariff applies? It's all of them. It's cumulative. So you could have a product, a piece of equipment that's subject to the tariff coming from Canada, and if there's steel included, also subject to the steel tariff, and all, and so you could end up with a 25, 50, 75% tariff on these items. So Not that I think you all are aware of the significance of it, and that's why I'm here talking to you about it. But certainly, this could cause really, really jacked up prices on things that you all have bid as firm fixed price. So let's move on to the next slide. These are the three things that I want to talk to you about today. Number one, we've already kind of covered. I don't think that we could end up in a situation where this is maybe more short term than it seems right now. But I think we need, as an industry, you need to be prepared for increased costs and increased prices. I don't think that it's going to be avoided, whether it ends up being not as bad or for a shorter duration than we think. I know that there was some movements in the markets in the last 2 days over the suggestion that maybe the president's going to back away from them again or lengthen the time. But I don't think hoping it doesn't come to full fruition is a good strategy. So what is a good strategy? One, you need to know what's in your existing contracts. And this is another point that I want to make when we get to the Q&A. It's my style. I want to be really interactive. I know with the amount of folks we have on the phone, I think we're going to try and save them till the end. What I'm probably not going to be able to do is answer everybody's question about their particular situation in this setting. For contracts that you already hold, and we're going to cover this a little bit, it's going to be really dependent on what's in your contract. And not only what's in your contract, but the entirety of what's in your contract, and that'll make more sense in a minute. But so it would be really irresponsible of me to say, hey, yeah, I think you can stick it to the customer on that one, or I think you're gonna have to eat that particular increased cost, because I don't know the entirety of what's in your contract. Certainly, if you want to sit down and have me look at your whole contract, I'm happy to do that, but that's just not what we're going to be doing in this particular setting. Again, not because I don't want to be helpful, but just because it would be kind of irresponsible for me to go off the top of the dome on some of those questions. But we're going to talk about what to look for in your existing contracts. What clauses are in there? What clauses aren't? And how the intent that you had when you entered into the contract can make all the difference. So we're going to cover looking at your existing contracts, and then certainly we're going to look at how to approach new contracts with this situation in mind. And I know in kind of thinking about this myself, there are some past lessons learned from tariffs, the steel tariffs over the last decade or so that have, that's an issue that's popped up intermittently with, the U.S. steel sale and all those kinds of things. So I don't think that, again, I think that there are some upcoming inflection points. That said, if the president were to back away from a particular tariff, I would not go, whew, dodged a bullet, don't need to worry about that again. I think incorporating some of the concepts and clauses that we're going to talk about is a good idea. We've got 4 years of the present administration. The president has called himself like Mr. Tariff or something like that. So I don't think that this is going to be an issue that is short term. And I think having these clauses in your contract that we're going to talk about would be a good best practice for dealing with material cost escalation, price, significant price changes across the board. So I think, I wouldn't look at this as a, kind of a niche issue or a limited short-term issue. So that's the way I would suggest that you approach the webinar. Okay, so we're going to talk first about standard construction clauses, construction contract clauses, I should say. And we're going to look at two examples, one being the AIA documents, which I imagine a lot of you are familiar with, the other being the consensus doc forms. Those aren't the only kind of form contracts. They certainly are two of the more popular. But I think that, even if you had what I would consider stock contract, or a contract that wasn't really specifically drafted for a particular project, I think you're going to kind of see similar terms across the board. So let's talk about what's not in most contracts. Most off-the-shelf contracts are not going to specifically address tariffs. So when this issue has come up, the clause that most folks go to, most AIA contracts are going to include that 201, which is the terms and conditions rider to the contract. And what most folks in the industry has focused in on is this clause that relates to the contractor shall pay sales, consumer, use, and similar taxes. So let's kind of pull that apart. Is a tariff a sales, consumer, or use tax? I think the case law is going to bear out that the answer is no. That a sales, consumer, or use tax is not the same thing as a tariff. So then the question is going to become, is it a similar tax? The answer there is, I don't know, and I don't think anybody does. And in preparing to talk to you all, I haven't seen any case law really anywhere that's directly answered that question. And so when we talked before about reviewing your existing contracts, the question of who's going to pay for a tariff, and is a tariff folded into the contractor's side of the ledger, either based on this particular clause or other cost of work clause is included in the AIA forms, is really going to depend on the intent of the parties. So if there is the suggestion that, hey, I've bid this as a firm fixed priced contract, and the expectation in looking at the contract as a whole is that whatever the cost of the materials is on the contractor, then I think that's the way the contract is going to be interpreted. And I think if your contract is silent on the issue of tariffs, that would be, I think that would be probably the expectation of how that would go, unless there are other parts of the contract that seem to suggest the ability to shift that. And we're gonna get into things like material cost escalation clauses. So that's the AIA contract. Let's talk about the consensus docs. The industry has looked to this particular rider for the consensus doc contracts, the 200.1 material price escalation amendment. And what that basically does is establishes a baseline price for materials and a mechanism for adjusting that price when the prices exceed a certain threshold. So this is a risk shifting provision where the parties have agreed that if there is a significant increase in the price of materials, that it's the contractor is going to bear the cost up to a certain point, and then it's going to be able to pass that increased price along to the customer. So in looking at this, I think what's important to understand is that this clause in the consensus docs and a material price escalation clause generally does not have to say if there is a tariff imposed. What it's going to do, again, is the parties in advance are going to agree upon a baseline price and then a percentage threshold for whether an increase in that price can be passed along to the customer. So there is a lot of flexibility within this type of clause for the parties to work together in advance to decide, okay, how much of this risk is going to be assumed by the contractor, and at what point does the risk become something that can be passed along to the customer. So moving on, again, I think that when you look at the two goals here, certainly what's in your contract is in your contract for things that are already signed. There's not much you can do about that now. Certainly, for those of you that are general contractors or in that position, I think what you're going to see is you're going to feel pressure up the chain and down the chain, which is to say, if you have subs on a project, I would fully expect those folks to try to pass those cost increases up to you through the owner. And then, the question becomes what's in your contract about those types of changes. And certainly, again, I mentioned before that I do quite a bit of work in the federal world. And there is a corresponding material price escalation clause in the federal acquisition regulation. And what you see a lot of times, and this was an issue that came up particularly when COVID was really at its height, was that you had supply chain issues, everything costs more. Folks that had a material price escalation clause in their contract would go to the owner and say, hey, I'm invoking this clause, my prices all went up, so you need to adjust the contract price. But certainly, I had lots of experience of folks that did not have that clause in their contract going and arguing it as just a, hey, I need relief. I need relief in this particular area. So what we want to talk about now is if you don't have that relief baked into your contract, that is what it is. But moving forward, understanding the environment that we're in now, I want to talk about 3 specific types of clauses that you should be contemplating to include in your contracts that can help you to avoid the situation where you've got those cost overruns and really don't have a mechanism baked into your agreement to help you deal with it. So the 3 are going to be a price escalation clause, a change in law or tax clause, and then force majeure. And when we get to force majeure, we'll talk about it. I've had folks already raising that with me to say, again, from probably up the chain and down the chain, folks looking to a force majeure clause in their contract and trying to use it as a catch-all to capture whatever it is they want to capture in the contract. And I think that's too broad of a reading, even though the force majeure clauses are typically pretty broad. So let's start with material price escalation clause. This is going to be really similar to the consensus docs 200.1 that we just looked at. It's a clause that you're going to include in your contract that's going to bake in how the parties are going to deal with significant price increases for materials. And like I mentioned, I think that the benefit of this type of clause, I put it first because I think it's the most practical and fair way with dealing with these types of issues is a price escalation clause, because what the benefit it offers the parties is that it's really customizable, right? It can be like most things in contracts, it can be generic, but it's the more specific you can be, the better. So if there are particular materials that you want to cover, you can do that. If you want to talk about size, duration, geographic location of where you're sourcing the materials, you can be as specific as you want to be in this type of clause. And again, the parties, it's a matter of negotiation, where you may get pushback on it, and you can negotiate out, okay, well, what percentage increase do I need to see until I can pass along that additional cost? And so it gives you the flexibility to say it's not immediate, right? It's not if this price goes up by $1 that I can pass that dollar along to you, but it has to go up 5%, 10%, 15%. And again, you can make a direct application for tariffs when you're negotiating this clause. So if again, it's another way to limit it, where if you want to directly tie it to tariffs being applied, I think that's totally fair, and at least you're protected from that particular contingency. Moving on to the next, a change in tax or law. This is, I think, a more specific type of clause that would have a specific index for tariffs baked in. I don't think that this wouldn't be my preference for a clause to include. I'd rather you all include a material price escalation clause because this is going to be more limiting. And I already brought up COVID once, but if there are supply chain issues, for example, that where you have price increases that don't relate to tariffs, this clause isn't going to help you as much. So a little bit more specific, but again, if you have a customer that's pushing back on a broad-based price escalation clause, this may allow you to at least get that relief for the specific instance of tariffs. All right, let's majeure. Force majeure clauses are very common in off-the-shelf contracts. Let's talk about what a force majeure clause is and what it isn't. A force majeure clause really is not meant to deal with price. So I know that there have been some folks have expressed concerns within your industry of customers saying or suppliers saying, well, my price went up and the contract includes a force majeure clause, and that means that it's an act of the government and therefore I'm able to pass that price increase on to you. That's really not the way a force majeure clause is intended to work. That's somebody trying to take a force majeure clause and squint and try to turn it into a material price escalation clause. Force majeure clauses typically do not mention tariffs. They more refer to sovereign acts of the government and acts of God. So, you often see things like war and strikes and things that a contractor would not have control over. And again, it's not supposed to be a price-based contingency. It's really a performance-based contingency. In other words, hey, if I'm not able to perform because I can't get access to these materials, then I get relief under the contract for my performance. But a force majeure clause does not then mean, well, and I can also charge you more because the cost of those goods went up. So I hope that makes sense. I also think it's interesting. I mean, now I'm going to go for the COVID trifecta, but certainly the force majeure clauses for project delays during COVID was a huge moment. It was a huge moment for force majeure clauses, and you had a ton of ink spilled on, hey, does an epidemic constitute an act of God? Does a pandemic constitute an act of God? So I think that I would not be surprised, just like we saw those words getting added to force majeure clauses in 2020, to see the imposition of tariffs added to force majeure clauses moving forward, to say, hey, if there's a increase in a tariff or an imposition of a new tariff, and that impacts my ability to perform, to get the materials that I need for whatever reason, that at least you're not in a position of a termination based on the tariff issue. So I just want to be clear about what force majeure clauses are and aren't. Again, they're performance-based, not price-based. So I think that, again, if to be protected on a price basis, you really need to look for those material price escalation clauses or something similar in your existing contracts. And if a price escalation clause is not part of your standard contract, I would recommend that you include something like that in your contracts moving forward, to the extent that that's something you're able to negotiate. So I want to make sure I leave plenty of time for questions. That's what I'd like to do with our remaining time here.
All right, Nick, thanks so much. Just for everybody on the call, we will send a follow-up email with Nick's presentation. So that'll be coming later this morning. If you do have a question, there's a raise your hand feature in Zoom. So if you click the react button It's in the shape of a heart. You can raise your hand and then I'll unmute you if you have a question you'd like to ask Nick. Seeing no hands raised, you do have the ability to unmute yourself. So if that's easier, just feel free to unmute yourself and you can ask a question.
I'd like to ask a question.
Oh, please, Rick.
Terrific.
When you could have a situation, in fact, it's quite likely that a tariff on a product will raise the price of a similar product that isn't subject to the tariffs. An example would be steel. If there are tariffs on imported steel, you could expect that domestic steel prices will increase as well. What are your thoughts on that?
So I think that's where, again, focusing in on particular types of clauses. I think a material price escalation clause is going to help you in that scenario because the reason behind the cost is not really at issue. The cost went up. If it went up by the agreed upon percentage or threshold, then you're going to get relief under your contract. That's why I'm not as hot for the change in tax or law provisions because something that's I guess what I would call an indirect impact is going to say, well, there was no increase on the tax or law related to that particular item. It just went up as a consequence of a law. So I think that that's why I would rather have something that just covers your prices as opposed to something that's directly tied to a change in the law. Does that help answer your question?
Yes. Thank you.
We added a clause to our proposals for our contracts. And if I read it to you, could you give me an opinion whether you think it covers what we're trying to do today?
I can try, sure.
All right. We reserve the right to increase the pricing quoted herein to account for force majeure events, the imposition of new or increased tariffs, shipping costs, import-export fees, duties, customs, or taxes, currency fluctuation, or increases in commodity or market pricing.
And that's in your proposals?
That's what we're putting on all the proposals we're sending out now to cover ourselves.
So a couple of things. One, if you can get folks to say that's agreed to, I think that's terrific. A couple of constructive comments. One, it is kind of broad, and again, what I'd rather see is a negotiated term that is agreed to and is actually baked into the contract. I'll tell you that for my clients, I strongly discourage them. A lot of times what you'll see is, okay, let's put together we have our contract that both sides are going to sign, and then we have contract documents that are attached to it, and I'm going to attach my sub's proposal to it, right? If I'm representing the GC in this scenario. Then there's an argument to say, hey, my proposal is stapled to that contract and therefore its terms are included. I tell my clients to never do that because then there's a question of, well, what controls what's actually in the signed contract or what's in the proposal. So I think having it in the proposal is better than nothing. But what I'd rather see you do is negotiate a similar clause. You're probably going to get some pushback, but at least if it's part of your contract, I'd feel better about your chances in arguing it. If it's just in your proposal, I wouldn't be as confident saying that it's absolutely going to protect you.
Okay, thank you.
Yes, sir. Rob, I see another hand up.
Yes, we have Bernie Schaefer with a question.
Hey, let me just be clear about we talked about this the other day. Uh, like for existing purchase orders that we have, are you saying that it's unlikely that they could use a force majeure reason to readjust those purchase orders that we've already placed, or what would be like a supplier's basis to do that?
Yeah, I think somebody who's pointing at a force majeure clause and saying, well, your contract has a force majeure clause and therefore I can change the price I'm charging you, I wouldn't accept that as a rationale. If there's not if they agreed to a price, now if they say, hey, I can't get the product, right? I'm having problems sourcing it, for whatever supply chain type outcome could arise from that, without seeing the force majeure clause that they're trying to rely on, it's kind of apples and oranges. Force majeure clause are meant to protect non-performance, not to jam through a price increase.
Right. Well, that's exactly what they're implying now, that it's a force majeure and we're going to adjust your purchase order
Yeah,
accordingly.
I would push back on that as a legal basis for adjusting a price for sure.
Okay.
And I think that if you were to try to pass that down to a customer and say, well, we agreed to a force majeure clause, therefore I can change my firm fixed price, I don't think anyone would buy that.
Okay. You guys are going to be busy in the next few months.
Yes, sir. I tend to agree. That there is that aspect of this industry is, when things stay the same, we're busy, and when things change, we're busy. So it helps me keep the lights on. Yes, sir.
Hey, can a follow-up question on that? I think Bernie's talking about the Schneider Electric force majeure language that was kind of circulated to all of us. Have you reviewed that? Because that impacts obviously all the electrical guys on the call to understand the impacts on us. From what I understand, not only can they change the price, but they could hold you in breach of contract if you then tried to cancel or not pay for that product as a result of the increase in price from the force majeure language in that specific
So
one from Schneider Electric.
I have not reviewed a specific clause. Is it possible that they folded in something to say, if circumstances without beyond our control lead to an increased price, we can hold you to that? I'd need to see it, because to me that would be something different than a off the shelf force majeure clause.
We have a question from Mike Phillips. Mike, feel free to unmute yourself. Mike, are you there? Hearing none from Mike. Let's see. Anyone else with the question?
I have a question. I didn't raise my hand. Cassandra Dulesky. I was looking to see. We do a lot of public work, plans and specs, and public bid openings. What are the ramifications that I deal with in terms of that? Like, is there any way for me to go back to the public entity through GC? Usually when I sign a contract, it's based on plans and specs, and it's whatever the owner has in there. There's no real negotiating that can be done on that front.
Yeah, I mean, it is going to depend on what's in your contract. Like I said, in dealing with the federal government, there is a price escalation clause that can be included in your contract. It doesn't have to be. And there is the element in public contracting of sometimes it's a little less hard and fast than private work, because there's just a little bit more flexibility on the government side. Again, not to beat a dead horse with the COVID stuff, but we did see scenarios under COVID where things that weren't in folks' contract, it was like, hey, like if you don't have some flexibility, then I'm just going to go under, and you're not going to get this, and you're not going to be able to get it cheaper from anybody else. because everyone's dealing with the same scenario. So I would say, one, look to what's in your contract, and two, you're not going to get it if you don't ask.
Right. Thanks.
We have a question from Chris Dion. Let me ask you to unmute.
Hey, Nick. Recently I got a contract from a large GC here in Philly that had in the Exhibit B electrical scope a section on tariff. And it reads as this: tariffs include all tariffs in effect as of award date. For clarity, it is understood that any new tariffs imposed by a government body after the date of award will be treated as a force majeure to the extent permissible under contract documents. That sounds pretty fair to me, right?
I tend to agree. I think you would have a strong argument to pass along additional costs there because it's tying the tariff to a force majeure. In other words, it's changing your ability to perform as agreed.
And it's given us a cutoff date of the award date. Now, what's the award date? Execution date or award date? Because that could also be construed differently, I think.
Yeah. So I tend to agree. And going back to I forget who asked the question, but on the Schneider Electric, if there is language to say, hey, price increases will be treated as a force majeure, I forget exactly how that was worded, then I think that I can see why they're making that argument to say, hey, we told you that this would be an act of the government or whatever, and you agree that you pay whatever the price is. If that's the way it's tied in, I can better understand that argument. Again, I'd need to see it, but from my perspective, that is a little bit of mixing your metaphors, referring to price increases as force majeure. So, Chris, I would take that and run with it to say, hey, I would try to use that to the fullest extent possible and bake it, your performance, your price, your everything. Hey, we all agree that a new tariff is a kind of changes the landscape. On the flip side, if I'm using that defensively, I'm going to try to say, hey, no, that only means your ability to source it, not your ability to price to hit me with an increased price.
Okay. And the other day I did have a conversation with ABB, who then reminded me that in their terms and conditions, tariffs are addressed three times, three separate ways. So I don't know, is our purchase order terms more stringent than their terms? Which wins?
Yeah, that's a great question, and I don't necessarily think I can't tell you the answer to that, because it's probably going to depend on what's in the contract, where it's being interpreted, whether there's any kind of an order of precedence within the contract documents for what's going to control. But that's I made the point when we talked about the AIA documents and just something referring to the contractor is responsible for taxes, right? I think that when there are competing interests within the same agreement, it's going to come down to intent. And if there's something to the contrary, and you can look and say, but wait a minute, you have to interpret that clause within the context of everything else that was agreed to, and therefore, the majority controls, as it were. It's a great question, and I think it's going to be a case-by-case analysis.
I appreciate it. Thank you.
Yes, sir. Thank you.
Are there any other questions? Nick, I did get a comment from the chat box asking if we would provide some examples to include in our contracts and purchase orders. So me and you can maybe work on that to send to the group after this call.
Yeah, absolutely.
Thank you. Last call for questions. All right, hearing none, I will be sending this presentation out with Nick's contact information. So if you do have any other questions for Nick, you can contact him through that email. I want to thank everyone again for hopping on And thank you to Nick for your time. We put this on within a short notice. So really appreciate Nick and everybody for hopping on. And I hope everyone has a great day. Thank you.
Yeah, Rob, I just I didn't flip to my last slide, but that is my contact info for anyone that needs it. And I would appreciate you circulating it. And yeah, happy to talk to anybody further if there are more specific questions after we're done here.
Perfect. Thank you.
All right.
Bye,
Thanks very
everybody.
much.
Thank you, Nick.
Thank
Hey,
you.